So Karen, before I even start talking about the legal and tax implications, I did want to share a simple story that explains how even the way a deed is worded is really important.
Mm,
So I had husband and wife. I had done their estate planning probably 5 years ago. And prior to me meeting with them, they had done a deed where they added their two daughters to the deed. Okay, so it was mom, dad, two daughters. And the deed said all of them, every individual owned a 1/4 interest, an undivided 1/4 interest. Okay. Now, when an attorney or anybody does a deed between husband and wife, you can actually own it as what they call tenants by the entireties. It's specific to a married couple. The thought being that a married couple, we want to protect their assets from creditors. There is a presumption that we like our spouse. So if one individual was being sued, let's just say husband was being sued, wife owns 100% of that property. So nobody's going to be able to evict the wife to be able to attach to that property. So it's a very specific titling concept for married individuals. Unmarried individuals can never own property as tenants by the entireties. They can only own property one of two ways. So the first is as tenants in common,
mm,
which just means that if you and I owned property and I died, my 50% would go through my will. You wouldn't automatically get it.
right.
If, however, we owned property as joint tenants with right of survivorship and I died, you would automatically get my 50% when I passed away.
Right.
So, and this is something that's so important because that couple that I was telling you that came in, they had done the deed thinking that husband and wife owned half of it as
Yeah.
tenants by the entirety, and then their daughters each owned a 25% interest. When
Okay.
in reality, the way the previous attorney had drafted it, they each owned a 1/4 interest. So when wife passed away, and she passed away about a year ago, when she passed away, her 1/4 interest actually went through her will. It
Oh,
didn't automatically go to husband and it didn't automatically go to daughters. And simply by having joint tenants with right of survivorship, tenants in common, or tenants by the entirety, actually designating what the intent was would have been really helpful.